Calling case number 23-01296 FY. This is people of the state of Michigan versus your appearance, please.
Ready, Your Honor. Good morning, John, and appearing on behalf of this.
Thank you very much. This is an arraignment of first impression. Mr. Engot, how are we proceeding?
Judge, I would ask the court for a formal reading just so there's no misunderstanding on this part. After the formal reading, I would ask the court to stand my client mute and enter a plea of not guilty.
Thank you very much. You're being arraigned on a felony charge. The court is going to read that charge to you. It is said that on or about July 15th of 2023 in the city of Royal Oak, County of Oakland, and state of Michigan, you did make an assault or an assault and battery upon a resident or former resident of your household, contrary to Michigan compiled law 750.81 subparent 2. There is a third offense notice in this matter, and you are to take notice that you have previously been convicted of assaulting and battering a spouse, former spouse, individual with whom you had a dating relationship, an individual with whom you had a child in common, or a resident or former resident of your household, or of knowingly assaulting a pregnant individual by violating 750.812 subparent 2 on or about January the 17th of 2019, and by violating Michigan compiled law 750.81 subparent 3 on or about January 5th, 2022. Therefore, upon conviction on this principal case before you today, you could be subject to an enhanced sentence under Michigan compiled law 750.81 subparent 5, a 5-year felony and or $5,000. Consecutive sentences may be imposed under 750.506 if the assault was committed in a place of confinement. To wit, this is a domestic violence third offense notice, and it is a offense which is said to have resulted in personal injury. That is the sum and substance of the complaint and general information. Mr. Engot, that having been done, what is our plea today?
Judge, we'd ask the court to enter a plea of not guilty.
Thank you so much. Plea of not guilty is entered upon Ms. Half, and she is requesting court-appointed counsel.
She is, Your Honor.
Proceedings?
Yes.
Very well. You're in a process now which is extremely serious and will get more so should you refuse to or confuse or otherwise obfuscate the process of your own criminal proceedings. You need to participate in this matter. You need to participate in this matter however you're undertaking to address the case. If you wish to prepare a robust defense, you need to participate and talk to your lawyer. If you wish to somehow seek a way to mitigate this matter, you also need to participate in the process. But you need to participate either way. This case is not going away. So the court strongly suggests you keep an eye on that mailbox and your telephone and your email, because the court is required to set a bond that serves two purposes, that ensures both your reappearance to court, and as well, the court is required to set a bond that provides protection for the public. And your lawyer is going to talk to the court about that right now. As well, Detective Hill, the investigating officer in charge in this matter, is present. Detective Hill, do you have any remarks you wish to make in the context of bond before the court hears from Ms. Attorney?
Again, Your Honor, Detective Hill, the Royal Oak Police Department. It should be noted, Your Honor, that a couple of important facts. Your Honor, Ms. was already just discharged from MDOC probation on May 14th of this year. Again, she has a lengthy criminal history for such a young person that shows 11 arrests since 2010. And Your Honor, as I previously stated to you and Mr. Engot, she has 8 prior arrests for assaultive crimes. I believe of those arrests, 7 of them resulted in convictions, including multiple felony counts. Your Honor, also, it should be noted that I do believe that alcohol was a major factor in this circumstance. I do have grave concern for the public and people that she has contact with, as she appears that she cannot stop from putting her hands on people. So I would ask the court to issue the appropriate bond, and please keep in mind that I do believe alcohol was a major factor.
Thank you very much. And with respect to a witness listed on the general information one, that was also a resident of that household on Campbell Road, is that right?
Yes, Your Honor.
And would you believe that some form of protection for is required as well?
She is the only other witness, direct witness in this case, Your Honor.
And is it your understanding that had been residing in that residence until
Yes, Your Honor.
last night or the night before? Okay.
Yes.
Thank you very much. Mr. Engot, what would you like the court to know with respect to your client's potential release?
Judge, from what little I know about the case itself, but looking at the criminal history, I absolutely agree that alcohol is a major concern here. And so whatever the bond money-wise is going to be, I would ask the court to add an alcohol tether for assurances, safety, and everything that goes with that 24 hours a day, 7 days a week. At least everyone will know whether or not Ms. is consuming. And I think that that is probably the key. As the detective said, it's probably the key to everything that's gone wrong in her life in the past. And so with that assurance, Judge, there are a couple other things. She has an address in Farmington Hills. It's over 13 miles from Royal Oak proper. I provided that address to the court. The only connection she has left with Royal Oak, other than that house to which she has been told by me and will be told by the court that she is to not return. She works at Cruz and Muir's, is what I'm told, on Woodward, and she'd like to be able to keep that job. That being said, Judge, should she be released, her vehicle is at the Royal Oak address, and she has some belongings there as well. I told her that the court would most likely order a supervised visit, that being with a Royal Oak Police Department officer, one time to go and pick up her car, not to move out, but to get essentials that she may have there and to leave that address and never go back there. She also understands, based upon our conversation, that there will be absolutely no contact ordered with the complainant. And I, as the court noted, I think the other witness in this case, she understands that no contact means exactly that. Nothing on social media, no third-party contacts. I told her that should that be ordered and should she violate any of those terms, jail will be where she resides throughout the pendency of this matter. I think she told me, and I have to agree, it's important to note that while she has just gotten off parole from the Michigan Department of Corrections, she successfully completed that parole. She did her time, she got off, she was good throughout the whole term of parole. When she was released from parole, I believe that's when the drinking started again. And here we go. It's like a merry-go-round. She's just back to point one again. The tether itself is, I think, the best defense that we have. I'm asking the court for something that I told her I don't think you're going to grant. But we talk about relativity here. And when we're talking about money, relatively speaking, a $2,500 10% bond might as well be a $100,000 10% bond for a person with means. It's a lot of money. It's all she will be able to come up with. And frankly, she told me $100. I told her it's not going to happen. I won't even ask for that kind of bond. That's what I'm asking for, Judge. Whatever bond you deem as necessary. I understand money-wise she doesn't have it. And I know that that's something that I would always hope, and I believe you do take it into consideration, is that people of means have a better opportunity to be released. Poor people sometimes just don't. And so that's where we are with it.
Thank you very much, Mr. Anga. Your remarks are well received, and the court appreciates the fact that she is gainfully employed. However, how is she squared away with respect to this address? Who else stays there?
It's her mother's house, Your Honor.
And she's welcome home to her mother's house?
Yes. Yes, sir.
Mr. Hill, Detective Hill, have you had any contact with Ms. Sprague's mother?
No, Your Honor, I have not. I had any contact with her family. Nobody's contacted me on her behalf.
Okay. So nobody has, as of yet, at least that we know of, called the station house to check up on her from her.
No one knew.
Either one of her, I'm speaking to the detective, either one of her parental units. Is that right?
No one has called inquiring about her at all, Your Honor.
Thank you very much. Mr. Rangot, is there anything further?
Nothing from me. Thank you, Your Honor.
The court is going to order as follows. Ms. You are to appear for all your future court dates as directed, abide any valid order or judgment entered in this case. You're not to leave the state of Michigan without permission of the court. You're not to commit any crime while you're on release status. You're to immediately notify the court in writing of any change of address or telephone through your lawyer or otherwise. You're going to be making reports to pretrial services. There's going to be no use of alcohol, marijuana, or any other controlled substance without a valid prescription from a treating physician. There is to be no release, I repeat, no release until you are fitted with an alcohol tether.
Okay.
You are also to, through the assistance of pretrial services and their facilitation, to attend intensive outpatient substance abuse and or alcohol therapy, as well as anger management.
Okay.
You are to have no contact with or you are not to cause to have any third party to have contact with. You are not to possess a firearm or other dangerous weapon, and you may return to for one time with a peace officer acting in a peace officer standby capacity to collect those items you need for your immediate change of address. So that would basically mean an overnight bag and your vehicle. With respect to that address, once that is completed, you are not to return to Fort. When the court says no contact, it means no contact. Not by phone, not by email, not by TikTok, not by Instagram, not by any of those things. And you are also strongly advised to heed the discussions that you will be having with very good counsel. They're going to be acting in your behalf.
Yes.
Under the rules and protocols of the Michigan Indigent Defense Commission. But they can't help you if you don't help them by at least being responsive. Mr.
Right.
Hagot, your client seems to have a question.
Yes.
I see that, Judge. I don't know what it is. I'm sorry.
I was just questioning because you said my family can't contact for any reason. But my credit cards and debit cards are in my car, which is at house. So for me to be able to get my alcohol tether, I would have to put my debit card in, which is at his house. So how can I go about contacting
That is something you'll be able to work out through your lawyer.
Okay.
All right. And the court will work on the assumption that other folks involved in this matter are not going to commit crimes. So the court would hope that or any other individuals aren't going to commit crimes by failing to return or using your own financial transaction devices. But that is an unfortunate consequence of what the court has before it today. With respect to bond amount at this time, the court is setting bond in the amount of $50,000 cash surety with a 10% provision.
So that is how much?
$50,000 cash surety with a 10% provision and no release without an alcohol tether. Do you have any questions?
Yes, does that mean $500 and then an all?
$5,000.
$5,000, $50,000 cash surety or 10%.
Have it, sir. Can you please?
Do you have any other questions?
Can you help me out just a little bit better on the bond, please, sir?
The court has before it a very alarming criminal history.
I understand
The court
that.
has before it multiple incidents of violence, at some times in turns, violence pointed toward police officers, violence pointed toward pregnant individuals. The court is extremely concerned about your well-being, not simply the well-being of others around you, but yourself. So the examining judge in this case at your next hearing may be able to accept and hear a motion from your counsel in terms of some modification of this bond. But at this time, that bond is exceedingly generous. So that's $50,000 cash surety with a 10%, no release without an alcohol tether. Any other questions?
Thank you, Your Honor. Thank you.
Thank you.